Thanks, Paolo and Lair, for the invitation and for organizing this terrific event. In this panel, we are going to talk about the status of competition enforcement in the EU and the US. And we are doing this with two prominent antitrust experts. Diana Moss, who is Vice President and Director of Competition Policy at the Progressive Policy Institute, and she was previously the President of the American Antitrust Institute. And Richard Wish, who is Emeritus Professor of Law at King's College. He was also a professor at the College of Europe in Bruges, where I first met him. We have organized the panel as an open discussion, a conversation, and we'll focus on three main topics. First, to understand where we are now, we are going to take a step back, and we see how we are going to discuss how the EU and US competition enforcement and policy have changed over the last 20 years. Then we'll come to the situation today, and we'll focus on, let's say, must-have topics. There is the enforcement and competition policy in the digital sector. And then we'll look, finally, at the competition standards and what is the status of the debate around the correct competition standard. With this, I leave the floor to the two speakers. So, Diana, where we stand now?
Well, thank you. And it is a pleasure, absolute pleasure, to be here and see many colleagues and friends from many years back, and to be in beautiful Rome. This is my surprisingly first time in Rome, but it is absolutely delightful. So I think we're in a moment in antitrust enforcement globally. We call it antitrust in the United States. You call it competition enforcement in other countries. I think that moment is becoming more of an inflection point as different countries take stock of the last 20 to 40 years of enforcement in their own countries and reassess potential standards, for legal standards and economic standards for showing harm either from mergers or from exclusionary conduct or agreements. And certainly in the U.S., we are in a bit of disarray, I would say. Most of you have probably already heard that the Federal Trade Commission yesterday, 2 days ago, filed suit against Amazon in what is a very interesting complaint. If you haven't already read it, you should read it. So the U.S. is really feeling its way forward in trying to strengthen enforcement, but dealing with different ideology on the antitrust competition spectrum. From the old spectrum, which was the far right, the conservative ideology that promoted consolidation and certain types of business practices that could be abusive, but nonetheless, that was all excused for reasons of efficiencies and benefits to consumers. And then there was the far left. So my old organization, the American Antitrust Institute, was on the far left. We now have a new voice on our spectrum, the neo-Brandeisian approach, which favors more bright line tests as opposed to an effects-based analysis in terms of showing the harms from market power and the adverse effects on consumers and workers. So that progressive voice is now sort of center-left. So we are duking it out, as you say, in the U.S. About what will prevail, what ideology will prevail, and how will the agencies try to strengthen enforcement. Along with that, we've had the growth of private enforcement in the United States, and now you all in Europe and elsewhere have some private enforcement. We have this unique relationship with our states, as you do with your member states, at least in Europe. But I think a major takeaway is that 40 years of lax enforcement, which was really indoctrinated in the courts by conservative voices, which argued for a laissez-faire, hands-off approach to business and to merger control and to certain types of conduct. That was really considered in the U.S. the way. And the U.S. went out of its way to try to tutor Europe and other parts of the country about how the U.S. way was the best way. Well, you know, that hasn't worked out so well for the U.S., given the problems that we're experiencing here. So we're in the middle of this reform movement and struggling with how to invigorate enforcement, but can't get any sort of constructive legislation out of our Congress. So I think the U.S. is no longer considers itself to be on the top of the heap in terms of counseling other countries on how they should structure their enforcement regimes. So I'll leave it at that.
Okay, well, good afternoon to everyone. Many thanks for the introduction. I'm a regular visitor to Rome, and it's always a pleasure to be here, especially leaving the UK on a day when the tail end of a hurricane was about to hit, Storm Agnes, and arriving in Rome and sunshine of 30 degrees. So it really is a pleasure to be here. So the first round of discussion is about looking back for 20 years to 2003. And when I started thinking about that, the first thing I thought was Regulation 1/2003, because I think it's been an absolutely remarkable development. I mean, we're talking about enforcement of the rules within the EU. And of course, Regulation 1 in its day was absolutely revolutionary. The idea that 28, originally, member states would have the power to enforce Articles 101 and 102. And all in all, it's really been a remarkable success. And an awful lot of the discussion when you're on the conference circuit and the webinars and the seminars tends to be about Google shopping and Amazon logistics and the big digital platform cases and whatever. But I think we should remind ourselves that if you look at enforcement across the EU, something like 70 to 80% of all enforcement is actually done at NCA level. I just had a quick look at the figures again this morning to remind myself. From 2004 to 2022, the Commission adopted 447 antitrust decisions, and the national competition authorities 2,644. So that does give you a pretty strong impression of how things are done these days. And if you look at the moment at the decisions that are envisaged in the short term ahead, the Commission's estimate is that 76% of them will be NCA rather than Commission decisions. So let's not lose track of that. And then related to that, I think it's rather interesting to see that quite a lot of the NCA decisions, sometimes they're fairly prosaic and local and a bid rigging cartel or an RPM practice or something like that, but also quite a lot of the decisions, especially in recent times, have really been quite innovative. Flexing the law, blue skies thinking, horizon scanning, and all that sort of stuff. And here we are in Italy. And several years back, the AGCM decided to look at the excessive pricing of the pharmaceutical company Aspen at a time when basically competition authorities did not do excessive pricing cases. And the AGCM did one, and it was successful in the end on appeal. And what happened next? The Commission said, oh, well, we'll have a look at Aspen's prices as well for the other 26 or 27 member states, eventually securing commitment. So I thought that was rather interesting to see the inspiration for a type of enforcement coming from the NCA level. And one could mention in Germany the Bundeskartellamt Facebook case, which the Commission did not take, but the BKA decided to run this idea that it was unfair, the way in which Facebook was obtaining and commercializing data obtained from the suite of different products. I know there's been a discussion this week on it, but I find the cases on denigration in the pharmaceutical sector extremely interesting, and there have been a number of them, including, of course, in Italy, but also France and Denmark and elsewhere. And now we see the Commission bringing an action against Teva, and in its press release, it actually says, oh, we've never done a denigration case before. It's really interesting. And you almost have the sense here that the Commission is learning from the NCAs. So in other words, this Regulation 1 system, it's not just about the Commission at the top establishing policy, which then cascades down to prosaic enforcement at local level. You sometimes get very initiatives locally, which ultimately might influence the way in which the Commission itself proceeds. What else would I say, big picture terms, about what the Commission in Brussels is up to? Very noticeable how few cartel cases there are at the moment. If you look back for the last 12 months, there's one cartel decision, military hand grenades, 1.2 million euro fine. And, it doesn't really affect that many of the citizens of Europe. We know that there are explanations for the reduction in cartel cases, but it is just something to be aware of. Diana just then mentioned private enforcement, and you said, I'm aware that you have got some private enforcement in the EU these days. I was actually going to say, I think one of the most amazing changes has been the deluge of private enforcement. There is so much of it now. It's a totally fascinating thing to behold. Obviously, the damages directive was quite important there. It has to be said the trucks cartel decision was even more important because there are fleets of trucks in every member state of the EU, and the law firms and the litigation funders have worked out how to bring the claims. In the UK, okay, we're out of the EU now, but the amount of private damages litigation in the UK these days is absolutely remarkable, not least because we've introduced collective proceedings, including on an opt-out basis. And there now are at least 25 cases where people are applying for opt-out collective proceeding orders in the UK. So that's been a remarkable initiative. The last thing I'll say for now, there are many other things I could have spoken about, but it's difficult for me not to mention the word Brexit, because if we are looking at the way in which EU law, if we're looking at the way that competition law is applied in Europe, it's kind of difficult not to give a few thoughts to Brexit. Firstly, in relation to merger control, because of course, when the UK was in the EU, you had one-stop merger control, and so basically the big mergers went to Brussels. But in the last couple of years, that has changed profoundly, and so we've got, I've written a few of them down here: Cargo Tech, Cone Cranes, Microsoft, Activision, Blizzard, Broadcom, VMware, Adobe, Figma. I could have mentioned about 4 or 5 others, where cases go to phase 2 in Brussels and at the same time go to phase 2 in London, and in quite a few of those cases lead to different outcomes, different remedies, sometimes something prohibited in one jurisdiction and not in the other. It's certainly added, added to the complexity of the picture. Separately, in the antitrust space, there was a time when the UK was within the EU where there was a statutory duty on the authorities and the courts to interpret UK competition law consistently with EU competition law. Since we Brexited, that provision has gone, and as each new initiative comes along, like renewing the verticals block exemption or renewing the horizontal cooperation guidelines or reviewing the liner shipping consortia, each time one of these hard or soft legislative initiatives unfolds, what we see happening is that the UK, for the most part, adopts the same position as the EU, but not entirely. So you end up in a very strange situation where, as I see it, as of today, with the antitrust rules, about 94.5% of them are the same as the EU, but 5.5% are different. And so for the practitioners in this area who don't want to be sued for professional negligence, they've got to be sure they're aware of the 5.5% of difference, because I think that's precisely the place where somebody could slip up in a piece of advice. So if anyone's doing anything on parity clauses under EU and UK competition law, make sure you check the 5.5% of difference in the UK from the EU. You have to do this, no doubt.
Can I ask Richard a couple of follow-up questions? That's a lot of information. So two things strike me based on some of the comments that you've made. So first of all, we always look in the U.S. at sort of what is the balance of enforcement across the different areas of the law. So for us, it's monopolies, mergers, and agreements. And cartel enforcement has always been sort of the bread and butter, as we say, of antitrust enforcement. But, in the U.S., we now have domestic cartels. It used to be, no cartels in the U.S. Well, we got cartels, for sure. We have a beef packing cartel. We have a poultry processing cartel. that do an incredible amount of damage to workers and to consumers. And so, you know, these are government agencies with constrained resources, and there's a lot of prosecutorial discretion and case selection issues. But what we have seen is a shifting in this balance, less enforcement against agreements, whether they be tacit or explicit agreements, more focus on monopolies, in large part because of the digital sector, but also from a swath of consolidation in the United States in agricultural biotech, for example, in live events, Ticketmaster, Live Nation. I mean, we have monopolies sitting around everywhere. And of course, merger control is sort of a baseline level of activity. But, you know, watching the shifts between the areas of enforcement, I think, is really telling about what changes are occurring more broadly in the economy, the role of the incursion of digital technology in virtually every sector now. It's not just a digital tech sector, it affects everything. Look at digital farming, look at online data platforms for healthcare, for example. So there's that. And then the other comment is the relationships between private, federal, and state enforcement in the U.S. are really incredibly complex, but also extremely important in terms of bootstrapping each other, cooperation between the states and the feds, cooperation between state, for example, and private enforcers. So any similar trends, Richard, on the European side?
Well, I think let me start with the cartel issue to begin with. Especially if we're looking back over 20 years. If you go back to the noughties, you know, that was the heyday of those cartels, you know, vitamins and carton board and gas-insulated switchgear, heavy-duty industrial stuff. And that often originated in leniency applications at the end of the 90s, early noughties. And then it took a long time for those cases to feed through the system. And we're not seeing those cases very much anymore. It is well documented around the world that there seems to have been a drop-off in leniency applications, and I would relate that absolutely to the damages claims, because let's look at trucks, for example. The fines in trucks were, roughly speaking, 4 billion euros. I have read estimates that arguably the economic harm caused to consumers in the case of trucks may have been in the region of 100 billion euros. Well, if I was the cartelist wondering whether to blow the whistle, and I'm taking into account all the relevant risks, is the risk of a $2 billion fine the big issue, or €2 billion fine the big issue, or is it joint and several liability for the 100 billion in damages with the associated legal and economist costs that go with that? So I dare say it is the case that the growth of damages litigation has inhibited the number of leniency applications. That then leads on to a kind of a different question altogether, which is what more can NCAs do to detect cartels without being dependent or overly dependent on leniency applications? And then you get into all this stuff about screening data and when you can use screening data and does it really actually pull in any cartels or not. I think the jury is still a little bit out on that. Please.
So 92% of private enforcement in the U.S. are Section 1 concerns, so anti-competitive agreements. And that really is what private enforcers do in the United States. Seeing a little uptick in monopolization cases, and now private enforcers are getting more involved in consummated Section 7 cases, so consummated mergers, right? And they never used to do that because there's no game in that. It's you're not going to get many damages, and structural remedies are a bit remote. But most private enforcement in the U.S. is in fact related to anti-competitive agreements. I think it's also worth pointing out, and I know we need to move on, that a lot of times the American Bar Association antitrust section files comments in all of your proceedings. There's a need to file as many comments as possible to let everyone know what the U.S. way is. And it is unfortunate, and this is a critical comment, that the American Bar Association often characterizes damages in private cases as duplicative of penalties taken in public enforcement cases, and that is absolutely not true. Private enforcement can get restitution for victims of crimes, and these are crimes, price fixing and market allocation, that government enforcement absolutely cannot get under the current system of penalties, at least in the United States. So I think it's an important point.
One thing I thought I would just come back, Diana, you mentioned about the balance of the portfolio of cases that any particular authority has at any given time. I think it would be fair to say, looking at the UK, for example, I think the CMA would love it if they had some more good cartel cases to do. And I think they are, for reasons I've already given, finding it difficult to find them. We did have a big construction cartel case earlier this year, £60 million fine, but there appear to be precious few cartel investigations underway. So what else is the CMA doing? They've had a huge portfolio of cases in the pharmaceutical sector, and they are still working through the appellate system, but 3 major cases with very big fines for excessive pricing, possibly inspired by the original intervention by the AGCM here against Aspen. So that's a big part of their work. And also, as of today, 2023 September, they've got cases against Apple, Google, Facebook, Amazon, and that is seriously interesting because pre-Brexit, those are cases that would have been done in Brussels. Now they're being done in the UK. And to some extent, they are proceeding in parallel, but there is still no formal cooperation agreement between the EU and the UK. So there are restrictions on the extent to which these authorities can exchange information, etc., because you run into constitutional problems and confidentiality problems and all sorts.
I think we should add the UK to the title of the session. So, very interesting what you said, Richard and Diana. So let's perhaps move to the second topic we wanted to discuss. There is the competition policy. So both in terms of enforcement and regulation in the digital sector. How this has been changing in Europe and the US.
Sure. So this is an ongoing question, especially for outside watchdog think tanks like the organizations I work for now, Progressive Policy Institute, and before the American Antitrust Institute. So I think I've done a lot of writing and analysis on the concept that competition in the digital sector really presents more of a public policy issue. These are big problems. There are economic effects. There are political ramifications, for example, free speech on platforms, which the U.S. guards very, very carefully. There are cultural effects. There are sociologic effects on young children and teens being bullied on social media. So, I mean, it's a real portfolio of problems that are significant enough to elevate the digital sector, competition in the digital sector to be a public policy problem. And coupled with that, you obviously have, you've got the digital platforms, I call them the digital business ecosystems, that are very unique economic organisms. They're unique business models with a platform and cloud technology and applications within the system. Lots of I'm an economist, lots of very unique economic features, scale economies in data, scale economies in cloud, network effects, information asymmetries about how users express their preferences for privacy versus how much information they actually turn over when they get into these digital platforms. So that adds to the complexity, and I think is really sort of the root of the idea that to address competition problems in the digital sector, you need a toolkit approach, which is strong antitrust enforcement, but also some sort of digital regulator. Not invasive regulation, price, entry, profit regulation, not public utility stuff, but certainly access regulation, right? Level playing field, non-discrimination, data portability, interoperability, all these things that we think of when we think about rivals operating on platforms. So I think the problem is such that it's going to require a toolkit approach. In the U.S., there is right now no hope, none whatsoever, that we will get any legislation that focuses on the digital sector. There are several bills. Senator Klobuchar had a bill that got a lot of airtime. We talked about it for a couple of years, and no bipartisan support coming out of Congress. Senator Bennett from my state of Colorado has a bill on how to set up a digital sector regulator. But the bottom line is it's not happening, and it's not going to happen anytime soon, not with the kind of dysfunction that you see in the U.S. political system right now. So, hence all of the emphasis is on the use of antitrust enforcement to really tackle problems that are fundamentally very difficult. And just as an example, one fundamentally difficult problem is if the government were to bring a case and win on liability, and then move to the remedy phase, what would a structural remedy look like? Would you break off a platform from applications, for example, and have it operating as sort of a standalone network, much like a regulated, public utility concept? Would you break up a digital platform, for example, Ticketmaster, which I know operates in Europe now, is our big monopolist in the United States? A lot of proposals to break up Ticketmaster into smaller pieces and smaller parts, and so that we have competition between smaller platforms. When you have network effects, what is to prevent a platform from regrowing to dominance, which is what we've seen with Meta, formerly Facebook. So I think there's a strong argument to be made that a dedicated, technically competent sector regulator really has the tools and the skills to develop a regime for this type of access regulation in the digital sector. And we haven't seen that proposal yet. We have seen it in the UK, obviously. But the US is about, 100 miles behind what is going on in other parts of the country. And so what's happened is, because we can't get anything on the legislative side, we have lots of cases. The Google search case is in trial right now with the Google Play case. There's the FTC suffered significant losses in the Meta Within case and the Microsoft Activision case. We now have this new case filed 2 days ago, against Amazon. So a lot of resources going into the digital sector. And harking back to Richard, your earlier comment, we have cartelization, price fixing, market allocation that is hitting consumers so hard in their pocketbooks, where lower income consumers in the United States are having to make really critical decisions about whether they buy food or whether they pay their energy bill. And I personally find that disparity in focus, all the resources going into digital. I'm not saying we shouldn't be putting resources in digital, but it appears to be that we are ignoring the types of just incredibly harmful conduct that really hurt consumers and hurt workers. And that, I think, is a coming course correction.
I mean, just on that very point, I've had discussions with NCAs across the EU who themselves would say, why does the Commission spend all its time on these digital markets? Because there are other things that are harming our citizens. So I've heard that point several times. The legislation point in the US, or the difficulty of achieving a legislative outcome in the US, is very interesting, because I always thought that the EU legislative process was very long and tortuous. I would never have imagined that the DSA and the DMA could get through as quickly as they did. I thought that was an extraordinary achievement of the EU, actually. In terms of the digital platforms, digital markets, I mean, the Commission has been extraordinary in this space since 2017 in particular. Let's not forget, by the way, however, I mean, when I was starting out in competition law, I won't say what year that was, but the first big case I was aware of was IBM, and it was about tying and bundling the software and the hardware in the IBM case. And the case was settled by the Commission because IBM had 80 lawyers and they had 3. And then, of course, there was the great Microsoft psychodrama 2004 to 2007. So we have been there, or rather the EU, I'm no longer part of it, has been there before. But from 2017 onwards, let's face it, this is under the Margrethe Vestager as Commissioner. 3 Google decisions, extant SOs against Facebook, Apple, Amazon. There's an investigation of Microsoft. I have no idea how many others there are. So very, very active area indeed. And 102 is adaptable, it's flexible, it can be extended to new situations. And I was hopeful in the early days that 102 was sufficient for the purpose, and I lost confidence in it for a host of reasons that we know very well. You know, how can you define markets when even the brilliantly clever engineers don't really know what it is that they're making? And then you have to define this market, and you're going to say it leverages to this one and to this one, and that's why you might end up with an ecosystem approach, etc. But market definition, market power, theory of harm, case precedents, it doesn't really work, it seems to me, and so you need something bespoke and speedier. Let's not forget, in Google Shopping, the complaint was in 2009 originally, and here we are, September 2023, and we are awaiting the judgment of the Court of Justice, which will come out in 2024, 15 years later. Hello, isn't there something about markets tipping? You know, so one can see the inadequacy, I think, of 102, and hence the DMA, and I think it is a remarkable achievement. Let me say, which chimes with what I said earlier, it is not only the Commission that has been active with 102, the NCAs have been as well. And there are very interesting decisions against the GAFAM companies by the Dutch authority, the Italian, the French, the German, forgive me, other competition authorities if I've forgotten you, but there's been a lot of NCA intervention as well as Commission intervention. What I think is very interesting now, and there's a panel tomorrow with the NCAs themselves, and I'm going to be chairing that. I think it's very fascinating to try to anticipate what's it going to be like going forward in terms of the balance between DMA enforcement, 102 enforcement, 102 enforcement by the Commission, where it chooses not to use the DMA, 102 enforcement by the NCAs, abuse enforcement by NCAs who have a stricter version of unilateral law than 102. I'm thinking of Section 19A, for example, of the German Competition Act about firms with just strategic significance across multiple markets. And then there may be national regulatory rules that also, to some extent, occupy the territory that we're concerned with. So going forward, there's going to be a very complicated jurisdictional puzzle, I think, to be sorted out, and we can see this already emerging in cases like Facebook Bundeskartellamt and the relationship of the GDPR to competition law, etc. So I think that's going to be very interesting to watch, added to which private litigation. I mean, this is going to be fascinating. And remember, the DMA is directly effective and directly applicable. I mean, people can sue if they're not getting what they want from the Commission under the DMA. They can also bring actions in national court. So that's going to be an interesting thing to add to it. And then, can I mention Brexit? Because, of course, you've got the DMA, but now in our Parliament, we've got our Digital Markets, Competition and Consumers Bill, which proposes a system of ex-ante regulation, but it'll be 5.5% different from the DMA. And so that's just going to be another part of the complex mix of tools that are going to be with us in the future.
So I have to say this because Richard, you've hit on something that I think is a bigger, older issue than many of us might fully appreciate. I started as a federal regulator. I worked for the Federal Energy Regulatory Commission as an economist in the merger shop for many years. It was probably one of the best jobs I've ever had. We were overseeing the restructuring of the U.S. electricity sector. Wholesale competition was growing and proving up real results in terms of lower energy prices. We had market-based rate initiatives. We developed merger guidelines. It was a blast, as we say. But even then, in the 1990s, early 1990s, how many years ago was that? We still had this too many cooks in the kitchen problem. And the too many cooks in the kitchen was federal oversight, state oversight, environmental, state level, regional level environmental agencies and laws and I mean, at any given time for a big utility merger, there were probably 5 or 6 authorities that had to render a decision. And any single one of them could have stopped the deal. That was it. If you couldn't get everyone on board, the deal did not go through. So that's a lot of cooks in the kitchen. We have this, so the concerns today with rising concentration and the development of dominant firms and oligopolies throughout the global economy, and the global footprint companies that operate everywhere and are now subject to every jurisdiction on the globe, it's a lot of cooks in the kitchen. At our state level, we have several initiatives afoot for states to develop their own antitrust laws. We have states with antitrust laws. California has their own law. New York has their own law. More states want their own laws. And that's fine, and that's good. It signals the importance of state-level enforcement, much like your NCA-level enforcement. But we're getting more cooks in the competition kitchen. And I think moving forward, that is going to be a real administrability issue, I think, for enforcement in terms of reconciling these different interests, different statutes, different standards, different interpretations. And you know, if you talk to companies, as I'm sure you do, they're very concerned about this.
No, well, I absolutely see that, and I think it's very interesting if you look at 3 judgments of the Court of Justice in the last 2 years. I've already mentioned Facebook Bundeskartellamt, that's recent this year, and that's about whether the German Competition Authority can investigate the same kind of issues that the relevant Data Privacy Commissioner can look at under the GDPR. And of course, what the Court of Justice says there, amongst other things, is that there's got to be proper joined-up coordination between the relevant Data Privacy Commissioner and the Competition Authority. You don't just barge ahead and adopt a decision without coordinating with somebody else over here. A less well-known judgment of the Court of Justice, I think this year, maybe the end of last year, was DB Station against ODEG, which arose in Germany in relation to access prices for access to rail infrastructure in Germany. And what was happening there is you have EU regulatory rules on rail transport, which then get implemented into German law, and there's a rail regulator created which has a monopoly of applying that regulatory framework and determining whether prices are fair. But that regulator hadn't made a decision in relation to a particular complaint, and so ODEG, the plaintiff, goes to a national court and effectively says, I'm fed up with this regulator, they just won't give me a sensible answer. I think the prices I'm being charged are abusive, contrary to Article 102. And then the national judge says, oh my God, what the hell do I do now? Because you've got fair prices being determined by the rail regulator in relation to which it has a monopoly qua guardian of the regulatory regime, and yet these prices apparently may be abusive, contrary to Article 102. How does it all fit together? And it's a fascinating judgment because, of course, the legal answer is 102 has primacy over legislation, over delegated legislation. So in that sense, 102 trumps, if that's not a rude word, the regulatory outcome. But then the court says, however, national judge applying 102, you can't reach the conclusion that the prices are abusive without first coordinating with the rail regulator. And then earlier, there was a case in Belgium where the postal regulator in Belgium had looked at the pricing tariff of the Belgian post office, decided it was unfair, but then that decision was overturned on appeal. And then the Belgian authority looked at the same prices and said they were abusive, contrary to competition law. The question for the Court of Justice, what has to happen in this situation where you've got 2 conflicting regimes? Answer, that competition authority has to coordinate with this regulator over here. And that was the Grand Chamber of the Court of Justice, 15 judges, almost as though they said, we need a grand chamber here, because this is important, and there's going to be more of it in the future when we've got the DMA. So I thought that was quite a smart move of the Court of Justice.
I think these are fascinating examples because we're going to see more of this as we get more, as I said, more cooks in the kitchen. So think about merger control, right? You have a regulatory authority that applies a public interest standard. Regulators do conduct remedies. They don't do structural remedies because that's what regulators do. They are there to ensure compliance and enforce their statute and oversee what is going on in the industry. So we actually had a couple merger cases that were subject to regulatory review by our Federal Energy Commission, but also DOJ filed suit to stop these deals. DOJ imposes a structural remedy, says sell off these power plants because they're the source of the incentive to foreclose competition. And the regulatory agency said, we're gonna monitor you. We're going to, force you to adhere to certain conditions, non-discrimination conditions. What do you do when you have two authorities with two remedies that do not work together in any way, shape, or form? And that was actually my job for many years, was to be a coordinator between all of the cooks in the kitchen. And there was a lot of sitting around conference rooms where nobody said anything and everyone just stared at each other. It was not a good experiment. Anyway, sorry, I had to throw that in.
I think, of course, we will have even more cooks in the kitchen in the future. And you mentioned before the standards, and I think this is the moment perhaps to move the discussion to different angle. That is, let's move back and see really to the competition standards. What has happened and how the debate have changed. Are we talking big is bad? Are we talking about consumer welfare? What has happened?
Mm-hmm. Yes, well, again, this is a key symptom of dysfunction in the U.S. Competition enforcement system or competition policy system, that we have a set of enforcers in place right now, not so much at the DOJ, which is a very different agency than the Federal Trade Commission, which is an independent competition commission that has its own statute, the Federal Trade Commission Act. But we have enforcers that were installed specifically because they had committed to going after digital, going after big, reining in monopolies, reining in abusive conduct by dominant firms. So I think it's safe to say that's why our enforcers are in the positions that they're in. And again, this harks back to the far left end of the ideological spectrum, known as neo-Brandeisians. They're also known in some circles as populists. There are so many names now, it's hard to keep up with what they're called. But so there's been a movement towards redeploying the intent of the perceived intent of the antitrust laws, to 100 years ago in the United States. Control of economic power means control of corporate power, and it's a very simple story that sort of drives this ideology. And so I think big is bad is definitely a pathway that our current set of enforcers would like to go down. But let's really think about what that means. A big is bad standard, as opposed to, say, an effects-based standard of let's look at a potentially concerning merger. Let's look at anti-competitive conduct, and let's figure out how that market power is enhanced and leveraged, and what the effects are on consumers and workers, right? In any market in the supply chain. That's the consumer welfare standard, which can be interpreted very flexibly in terms of price effects, non-price effects, quality, innovation, input markets. You can have an effect limited to an input market, an effect limited to an output market on the consumer side. Very flexible standard, very different from big is bad, which is a bright line test for illegality. And if you look at our new proposed merger guidelines in the 2023 merger guidelines, you will see an attempt to, what appears to be an attempt to create a big is bad standard, And what is, in very few words, what has happened is all the economic tools and discussions and methodologies were taken out of the guidelines, at least the first part of the guidelines, and it was all relegated to appendices and very distant sections on page 50 and page 60. So it creates this optical sense that there are these bright line tests, the structural presumption, now a presumption for vertical mergers, which I have been advocating for many years, a presumption against dominant firm acquisitions of smaller rivals. The list goes on and on and on. But it is not at all clear, and we worry about this in the courts because judges have, the guidelines aren't binding, but judges do follow them. They may be very confused about what is the prevailing standard now under our new merger guidelines. And so I think that is the debate that we're having. If you look at the Amazon case that was filed, I've now used that example 3 times, you will see that the way the markets are defined in the Amazon case, there's a consumer-facing market for online superstores where consumers go to Amazon to buy everything that they need, and they only will shop in a superstore format. There's another market for a buyer-facing market, which is the access to marketplace services for sellers on the Amazon platform. Those markets appear to have been defined not based on consumer substitutability and how consumers make switching decisions, but based on where does Amazon have the biggest market share. So defining a market, finding a big market share, and then saying the market's going to be defined around that big market share and it's going to be limited to this particular market is typically not the way, as we know, market definition occurs. So we're beginning to see sort of more and more evidence, more and more a popcorn trail of how big is bad is sort of working its way into the current set of cases that are being selected and litigated in federal court. But again, this all happens in the courts. And we have generalist judges in the United States at the district court level who do all sorts of law. They do criminal law, they do corporate law, they do antitrust law. They are not necessarily antitrust experts. So this will be very interesting to see how our judges in the United States process these initiatives to bring a sort of a big is bad standard into play.
Well, I think the whole issue of standards is endlessly fascinating, and it's much debated. It's debated in academic circles, but of course it's debated at OECD and ICN and within competition authorities, and it will be debated forever, I think. And a lot of people do try to find out what is the purpose of competition law, as if there is some kind of magic answer to the question. First, very prosaic thing I would say is there are 130 to 140 different systems of competition law in this world. Some of them don't articulate in the legislation what their purpose is. Others do have specific rules about specific things, and some systems of law do specifically say that they are intended to protect small and medium-sized businesses. Well, if a law says that, forget our as efficient competitor discussions. If the law actually systematically favours a particular group, then an authority or a court has to apply that law. And if South Africa says that in reaching decisions under competition law in South Africa, you'd have to take into account the position of historically disadvantaged people, that is to say the victims of apartheid, you can't say, oh, that's a silly law, this should be about consumer welfare. You have to apply that law. So, I mean, the first thing I would say is there is no one-size-fits-all answer to this. You've always ultimately got to go back and look at the law in question. But there is a very vigorous debate now about Chicago School, post-Chicago School, neo-Brandesians, etc. And it's a particularly obvious debate at the moment, in particular because of the rise of the digital platforms, and everyone is very aware of these kind of issues. But there is a pendulum of enforcement in the States, in the EU, and this pendulum moves backwards and forwards all the time. And, you know, if we go back to 1890 and the Sherman Act, why was there a Sherman Act? Because of the incredible monopoly power that existed in some parts of the economy. And possibly nobody has had that equivalent power until today with the digital platforms. So a lot of the debates as I see it unfolding today kind of takes me back to the 1880s in a certain sense, and indeed the 1912 presidential election in the States, because the rules were there, but they weren't being enforced properly. So that led to the FTC Act and the Clayton Act of 1914. So, and then subsequently you get high levels of intervention and the Warren Court, and then subsequently you get the Chicago School, which is a backlash to that, and then some economists saying that Chicago stuff is not all necessarily right. And then we get the Neo-Brandesians. You gave various names that they've been given in the conference circuit. I've also heard them referred to as mad lefty academics in West Coast universities. But there are lots of different terms for the Neo-Brandesians. But I think the serious point is that this pendulum swings all the time, and competition authorities, they're bound to take into account the circumstances of the day. And I think it's been fascinating the last 15 years. You get the financial collapse in 2008, 2009. Very quickly, competition authorities had to say to themselves, how are we going to deal with the financial collapse? Are we going to allow lots of mergers? Are we going to allow lots of cooperation agreements to get us through the tough times? And I thought it was remarkable how the authorities very quickly got their act together and acted for the most part in concert. And then subsequent to that you have COVID, and then you have the Ukrainian war, and now you've got climate change, the sustainability. Of course, competition authorities take all this stuff into account. Also, inequality of bargaining power within labour relations, where it does seem that things have shifted a long way in favour of the employer against the employee. So, of course, authorities take all this into account. And I think when we start having public interest type discussions, I think we need to make a big distinction between the authority that sits down at board level to decide what are its enforcement priorities, what kind of cases does it want to do. Well, I think at that stage, inevitably, you're taking into account the public interest. And you might say that the public interest means that we should intervene more in the case of disempowered consumers than oligarchs who have been the victim of price fixing for their billion-dollar yachts. I think the public interest might suggest that one goes for the consumers rather than the oligarchs when we decide who to protect. So there's always a public interest element to the work of a competition authority. That's quite different from doing a case when you have to apply the actual law. Now, the actual law might be very specific as to what the relevant criteria are, and that there may well be no general public interest consideration. So I think that's an important point to bear in mind. As for consumer welfare, well, I think you said, consumer welfare can be interpreted in lots of different ways. And I think it was Mario Monti who on one occasion said when he was Commissioner for Competition, I don't mind us talking about consumer welfare as long as we can all agree that none of us know what it means. And I think if you leave it at that level, I think it's absolutely fine. Competition authorities try to act for the welfare of consumers. Well, let's call that a consumer welfare standard. I'm happy with that. If consumer welfare means that the authority has got to prove that prices are going to be 3% higher than they would have been in conditions of competition, well, forget it. We may as well just abandon competition law and go home. What I think is incredibly impressive these days is the extent to which competition authorities do talk to one another about areas of policy. And it may well be that through having international discussions, one does softly converge. It may also be that we have discussions about where we are on sustainability, and we actually might decide amicably to disagree, and then you have divergence. And I think when it comes to the whole sustainability agenda in the EU, you've got the DG Comp with one view of sustainability and in-market user benefits, and the Dutch authority possibly is going to have a different version, and the Greek authority may have a different version again, and we in the UK have come up with a specific thing in relation to climate agreements, which is different from other types of agreement. I think sometimes informed divergence may not be a bad thing, because then you can watch these live experiments as they unfold, and it might be that 10 years later you say, oh, actually, no, I think the Dutch got this more right than the French did, and we all learn from it.
So are we back to 100 years ago, Sherman Act and the Standard Oil case and the Bell case, you know, the initial cases against big companies?
I think we, the resurgence of monopolization enforcement, I think, is really an interesting thing to watch and to track. Because we have seen an incredible swath of consolidation. And this is 40 years of weak enforcement in the United States, leading to high concentration, dominant firms, tight oligopolies in really critical markets: transportation, energy, food, healthcare, you name it, and digital. So it's only it's only natural to see more monopolization cases being brought, and they should be brought. The first line of defense, I would argue, against dominant firms and oligopolies is strong merger control, right? If you get it right and you enforce, you engage in strong merger control, then you don't get dominant firms and oligopolies, unless they are arising because of other economic phenomenon. I guess my only comment is, if we're going to increase enforcement of monopolization law and exclusionary conduct, then let's do it across the board. Let's not just do it in the digital sector. Let's look at all situations where consumers and workers are being harmed by significant buyer power. And you're absolutely right, Richard. Workers are on the short end of the stick. They have lost a lot of their bargaining power over the last many years. Unions are waning in the United States. We now have a more vibrant labor movement in the United States. Lots of strikes in the U.S. right now. And all my grandparents were union workers when I was a little kid. And that really made an impression on me. So, you know, typically pro-union. But workers have lost bargaining power. Consumers have lost bargaining power. So if we're going to enforce monopolization law more vigorously, let's do it in a balanced way. And let's figure out where we're going to, how we're going to pick cases that are going to really benefit consumers and workers in the biggest possible way. And right now, I think that's a harder argument to make for digital, where you're really not talking about prices. At least for users in a digital ecosystem, you're talking about use of data, abuse of privacy. You know, these are non-price effects under a consumer welfare standard. So that I speak personally that this poses a conundrum for me in terms of the resources that are going into enforcement.
We had a very interesting discussion. I think we are running out of time. So, Richard, unless you have any final remarks, a big applause for our speakers.
Thank you.